Welcome to the Florida Divorce Podcast, your source for the information you need to successfully get through your divorce and into the next exciting chapter of life. Now, here's your host, Attorney Scott Kalish.
Hi, my name is Scott Kalish, and I'm a divorce and family law attorney here in South Florida. Today, I want to talk to you about the issue of alimony, and specifically the scenario or the situation where one spouse is either unemployed or underemployed, right? And this is a situation that we come across from time to time. It's actually pretty common, where typically it unfolds like this, where the spouse that's being requested to pay alimony, right? The paying spouse comes to us and says, hey, my wife or my husband, the would-be receiving spouse, they can go and work, right? And if they worked, I wouldn't have to pay alimony. Or they're in a position where they're not making what they actually could make if they took the job that they're, trained in, right? They're underemployed. And again, underemployed is, hey, they're in a position where they could be making more money. They're licensed to do a certain job, or maybe they have the skills to do a certain job. Maybe historically they worked a certain job and they're voluntarily in a job that's a low paying job and they're not making what they could, make, right? And the way that we handle this, the way we combat this is we argue to the judge that the court should impute income to the other person. And what I mean by imputing income is I mean that the court can, under certain scenarios, and there are certain requirements legally, a court can essentially treat that person as if they were making, more money than they actually are, right? So it's called imputing income to them, and there's some requirements that we have to show, we have to prove before the court legally, can do it under Florida law, right? So let me go through the requirements of what we have to show, and then I'll talk to you a little bit about how we actually do it, right? Sort of like the nuts and bolts of how we put it together. So, the first thing we have to prove is that they're voluntarily in this position. They're either voluntarily unemployed or voluntarily underemployed. And what I mean by that is, hey, this is their choice. Nothing's holding them back, right? And a classic example of someone being legitimately unemployed or underemployed, right? So when they're involuntarily underemployed or involuntarily unemployed, is when, hey, maybe they have an illness, a legitimate illness or a legitimate physical disability where they're just not able to go out and work, or maybe not able to hold the same position that they once had. I'm dealing with this right now in a case, and my client's position is that it's not legitimate. The person's claims about being underemployed is just not legitimate. The decrease in income is voluntary, not involuntary, right? So this is something that I'm grappling with right now. But that's the first requirement. The second requirement is you have to be able to show, right? And this is an important aspect of this, just to back up for a second. If you're the spouse that's asking the court to impute income to the other spouse, this is your burden of proof. You have to show, you have to demonstrate with evidence that the court can legally impute income, right? So you have to meet these requirements with evidence. It's not the other spouse's burden of proof where they have to come in and defend this once you raise the issue. No, you have to come in with evidence showing that you have met the requirements from a legal standpoint to where the court has the power, the authority to impute income. So that's a very important aspect of this, because you have to go on the offensive here. It's not about playing defense in this scenario. If you want to impute income, you have to prove it. So the second thing that you have to show is that the unemployment or underemployment is the result of the other person pursuing his or her own interests, right? And basically showing that they're engaging in less than diligent efforts to find employment, right? So this is best illustrated by thinking of the classic scenario, right? The one spouse prefers to have, lunch on weekdays, go out to lunch on weekdays, get their car washed, their hair cut, their nails done, shopping, things like that, rather than going out and actually finding a job by using diligent efforts, which is putting applications in, interviewing, researching job opportunities, networking, those types of things. If you're able to show that your spouse is using less than diligent efforts, right? Again, going to the gym, those types of things, instead of, legitimately going out and find a job, then you'll be able to meet the second requirement. And the next sort of part of this is to show, all right, what can they realistically make? And what you'll have to show the judge is you'll have to show their employment potential. You're going to have to show probable earnings based on work history. You have to show their qualifications. You have to show what people are making in these positions, right? What are the prevailing wages in the community? Again, this is your burden of proof. If you're the one that is asking the court to impute income to the other spouse, then you have to, come to court with evidence of those requirements. You have to show that the judge has the authority, has the ability in your case to do what you're asking him or her to do. Now, how we actually do this, right? The nuts and bolts. I mean, typically we hire an expert. We hire a vocational expert to come in and do an evaluation of your spouse, right? Hear what their skills are, what their, if they have licenses, if they have, specific industry knowledge, what their qualifications are, what their work history is like. And then the expert also examines what the, job prospects are in the community, right? What opportunities are there and what are similar people making in those job opportunities. And that's typically how we tackle this issue and how we demonstrate to the judge that, hey, judge, you have the authority under Florida law to impute income to the other spouse. And sometimes that does it, right? And that works. And the judge finds, hey, this person, can go out and support themselves. So alimony is not going to be a factor. Or this person maybe is underemployed and they have the ability to make, let's say, 50% more a month. And therefore, alimony should be a lesser number than what the person is requesting. So it's imputing income is something that we can do. It's not the easiest thing to do, again, because you have to have an expert. And obviously the issue has, two sides, right? So you can hire an expert and you can, argue this. And I'm sure the other spouse, right, if they're going to contest it, right, as part of their defense, is they're going to hire their own expert. They're going to say, hey, there aren't these opportunities out there, or if there are, the amount of money that these people are making is not the same as what the other expert is saying, right? So there's going to be differing of opinions at times. So it's not so straightforward, not so clear cut. But again, if you do want to go down the imputation of income route, an expert is highly, highly, highly recommended. So that's essentially how we tackle that issue, right? The issue of when one spouse is being, unemployed or underemployed. I want to mention that, the role can be reversed, right? The person that's requesting alimony, if they believe that, hey, the would-be paying spouse, can make a lot more money, or now is just being, unemployed because they want to avoid paying alimony. This exact same analysis, the exact same tactic tool, right, of imputing income can be used the other way around. So, but typically it's used, I would say, based on my experience, it's used as a defense to alimony rather than as an offensive tactic. But again, it can be used equally, on either side. If you like this podcast, though, please give it a 5-star review. I really appreciate you guys listening. I'm hoping that you guys are getting value from this. I want to let you know that I'm starting something new with the firm. I'm creating a family law and divorce Facebook group. So if you are enjoying this podcast, and you're interested in connecting via Facebook and you have questions and you'd like to have the questions answered, please join the Facebook group. I think you guys can get a lot of value from that. We're just starting out now. I'll put a link in the show notes, right? So visit the show notes if you're interested in that Facebook group. If you guys have a question for me, also, if you want to discuss things more anonymously, not in front of others, feel free to shoot me over an email. My email is scott@kjlawfla.com. Again, scott@kjlawfla.com. If you have a question or if you'd like to discuss possible representation, shoot me over an email. I'm always open to discussing, your questions or potential new cases. All right, guys. Thanks so much. Appreciate it.
Thanks for listening to the Florida Divorce Podcast. To learn the 10 secrets behind every successful divorce, visit floridadivorcepodcast.com. If you'd like Scott's help in your divorce case, go to kjlawfla.com.